No one really understands the Maritime podcast. Not even Hector or Ethan. And they are the ones running this ship.
I think it's time for you to know the awful truth. The truth about me and the truth.
Welcome back to the Maritime podcast.
Hello there, I'm Jim.
Please use your real name. This isn't a funny bit. This is an educational podcast, not an entertainment one, you absolute buffoon.
Okay, my bad guys. I'm Hector. How you doing?
And I'm Ethan. So today's topic is going to be on the Civil Rights Act of 1964, and also the implications of it now, and as it was in the past. We love a good bit. So the actual law part we're going to be focusing on is Title VII. To quote it fully, Section 703A. It shall be unlawful employment practice for an employee to 1. Fail or refuse to hire or to discharge any individual, or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment, because of such individual's race, color, religion, sex, or national origin. 2. To limit, segregate, or classify his employees in any way which could deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee, because of such individual's race, color, religion, sex, or national origin. That's from the actual Congress.
A lot of what is going... I don't know what to say. My bad.
Yeah, you can totally just like...
Alright.
We'll fix it in post.
Yeah.
Oh, sorry, I'll fix it in post.
Yeah.
I definitely won't leave this bit in.
Alright, for sure. Man.
Uh-huh.
It was Title VII and Title IX that further enforced these acts through the creation of the Equal Employment Opportunity Commission, and along with Title VII, there was Title IX that was part of the Education Act of 1972, which forbade gender discrimination in education.
For more background information on this act, writer Linda Simmons, I believe her name is, wrote an article that basically gave good background information. To quote her directly,
the provisions of this Civil Rights Act forbade discrimination on the basis of sex as well as race in hiring, promoting, and firing. The word sex was added at the last moment. According to the West Encyclopedia of American Law, Representative Howard W. Smith, a Democrat of Virginia, added the word. Smith, however, argued that he had amended the bill in keeping with his support of Alice Paul and the National Women's Party, with whom he had been working. Martha W. Griffiths, Democrat from Michigan, led the effort to keep the word sex in the bill.
and that was Linda Simmons. Ideally. It's probably going to be my voice in some sort of voice acting thing, but still. Who knows?
As an add-on to what the background was, the term sex was extremely subjective by the implications of Howard W. Smith, which was a conservative in Congress during the time that this law was passed, in hopes of killing the bill, or rather putting a poison pill in hopes of having this bill completely terminated rather than being passed like it was now.
All right. So the current situation is now, right now the Supreme Court is actually considering a certain case, a multitude of cases that are coagulating. Is that the right word? I feel like that's a gross way to put it. Coagulating.
Not using that word.
These cases that were coagulating in the Supreme Court. Essentially, what's happening currently is the rights of LGBT workers. Many of them have been discriminated against because it hasn't exactly been enforced for their own discrimination in their employment. To quote the New York Times, in a pair of exceptionally hard-fought arguments on Tuesday, the Supreme Court struggled to decide whether a landmark 1964 civil rights law bars employment discrimination based on sexual orientation and transgender status. So basically, it's like...
It's kind of the final implications of the Civil Rights Act of 1964. As we further go on into more individualized people, the implications of this act have become more and more gray, per se. And now
Supreme Court
is trying to widen and broaden the implications of this act.
Did you mean Supreme Court?
Yes.
Okay. I could ADR just like, instead of using cars, I put like Supreme Court.
Yeah. I'm like, my train just stopped.
Oh, no.
He's like, oh no.
Don't worry, I won't leave this in, probably.
Probably.
You know,
I'll
probably.
be confident.
Who knows? One of the major arguments is on the specific wording of the law, where it specifically noted sex. In the New York Times, they quoted a Miss Carlin, an attorney, who stated that sexual orientation discrimination was a form of sex discrimination. Basically, what we're going down is the fact that it's a test of, if this were a man, would you fire them for the same offense if they were a woman? So if this woman was dating a man, would you still be firing them if it was a man dating a man? So, you know, that sort of thing. Those sort of arguments are being made. At the moment, it seems that the court jesters, you know, the Supreme Court, the court jesters. We love poking fun at our U.S. government. You know, they're probably going to be divided among the usual, you know, like Republican Democratic lines, for the exception of a Justice Neil M. Gorsuch, who is among the conservative majority, but his questioning might show that his vote could sway either way. So, the implications of this in regards to LGBT workers. So the thing is, for a lot of LGBT workers, the act of employee discrimination is not great, especially economically. I believe that Jennifer Pomerantz put it in her academic article, if I can find it. Jennifer Pomerantz put in her article, challenging and preventing policies that prohibit local civil rights protection for lesbian, gay, bisexual, and transgender, and queer people in the American Journal for Public Health. She put it as,
Even if Arkansas was simply seeking to accommodate religion, Act 137 imposes economic and other burdens on LGBTQ persons and their families to advance the religious belief of those accommodated. Through Act 137, the state is giving the force of law to religious business owners who wish to discriminate against same-sex couples. Thus, the statute goes further than constitutionally appropriate to accommodate religious beliefs.
and that was definitely her and not me doing some voice acting stuff. Hector, do you want to add anything to that?
Well, to add on to the current legality of discrimination is that it's still protected, although looked down upon, but in order to actually discriminate against LGBT people, it's still completely legal, which further arises our situation currently with Congress, which is that's important enough.
Yeah. Or the Supreme Court, right?
Yeah.
Supreme Court, which, yeah. All right. Well, I believe it's time to get to our sponsorships. So, and then at that point, I'm gonna put a musical stinger to get transition into it. Okay. Today's sponsor is Chick-fil-A.
All right, guys, just remember, eat more chicken.
Yes, we love you, Chick-fil-A, definitely, and the fact that you are most certainly not funding executions of gay people in other countries.
Chicken sandwiches are pretty tasty.
I actually haven't had it. Have you?
Nah, they're pretty tasty, bro. They're fire.
What do they taste like?
Tastes like chicken.
I want you to describe this in vivid detail.
Well, I can't do that. This isn't Ratatouille.
This is why we hate Pixar. Anyway, next sponsor is sponsored by no one else. So please, if you would like to sponsor us, our email is maritimepodcast@gmail.com. And then we'll have a little stinger at the end where it's a little musical outro.
Okay, yeah, I'm done.
And it's probably gonna fade in as I was saying that. Any last words?
Have a great day.
Is that gonna be your outro? And remember, have a great day.